This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today's guest is Richard Leisner. Mr. Leisner is a senior corporate and securities transactions attorney at Trenham Law, as well as an expert witness in high-stakes business litigation and legal malpractice actions. He holds a number of distinctions, including Tampa Magazine's top lawyers list, and is a published author of numerous articles and legal blogs. Mr. Leisner holds a JD from the University of Pennsylvania. Mr. Leisner, thank you so much for joining me here today at the Roundtable.
Well, I'm glad to be here. You made me sound pretty good.
Well, you have a storied career. Let's jump into it. You have over a half a century of experience as an attorney, but simultaneously you're a sought-after expert witness, which really gives you a unique perspective on both sides. How did you first get into expert witnessing?
I've got a phone call from a retired senior official from the SEC with whom the bar had done a lot of work. And she was a storied corporate finance lawyer at the SEC, a woman named Mickey Beach, Mary T. Mickey Beach. And she said, you might like to do this, defending this big national accounting firm out in Spokane, but I'm not going to do it because I'm going to China. And I said, because she was like a big sister to me, I said, okay. And the next thing I know, I was doing my first big expert witness gig.
Had you been using expert witnesses up until that point? When was this?
This was more than 20 years ago.
Okay.
For the turn of the century. And I'm a deal lawyer.
Sure.
Company's public, I buy them, I sell them. We're a little unusual because we're out in the sticks. So I have a broader base of transactional experience than if I'd stayed in New York where I started. So sure. I've done IPOs, I've done spin-offs, I've done split-ups, I've written option plans, I've done stock exchange listings, I've defended SEC investigations. And what I have said is that if a deal is screwed up, which is what you wind up with in expert witness cases, chances are I might have tried to do it correctly during my career as a transactions lawyer. I do a lot fewer transactions now than I used to. I'm on since I took senior status at the firm a few years ago, I'm on associate row. So people will come down the hall and say, Rich, what do you think about this? Now you can't bill for this, but they told me I should come and talk to you. So I never used an expert.
Okay.
I didn't know an expert from Adam, and so I got on the phone with a senior partner at a well-known national law firm because the accounting firm was a national accounting firm, although the litigation was in Spokane. And he said, "Well, why don't you tell me what you think about this issue in the complaint?" So I wrote him a letter. I didn't know what an expert report was. I didn't know what Rule 26 required, which is where all the guidance for federal expert reports is. Although one of my partners mentioned to me the other day that Rule 26 was a lot thinner when I started doing this than it is today. So I didn't know anything about that. And so if you're going to be an expert, first thing to do is to read the instruction book, which are a couple of the federal rules, even if you're in state court, that you need to know that. And
sure.
So, I went to Spokane, where the courtroom looks just like something out of Back to the Future, and I had some terrific lawyers, including the local counsel, who gave me a master class in what you should and shouldn't be doing when you're an expert. And so I kind of lucked out from that association. My guys won, that there was a zero liability, and the case was appealed on my testimony. And the judge said, "Oh, Leisner's testimony is okay," but they didn't report it. So so it's an unreported opinion from a long time ago.
Sure. Absolutely. Was there anything that surprised you as an attorney about being an expert witness? Something that was unexpected, or anything that was, you'd been in law for so long. Was there anything still that was like, wow, it's really surprising to be here on the other end, working for an attorney rather than as an attorney?
Yes, I didn't, and I had been in one case about 7 or 8, 15 years before that, but I never did. It was my first and only case. It was a criminal case, 56 counts, not guilty, at the end of a 1-week trial. I didn't know what experts can and can't testify about. They asked me what I thought about what the poor defendant, the person whose side we were on, what they had done, and whether or not the real estate he had sold were securities. And I said, no. So I started explaining why one of the charges couldn't go forward, because the events didn't take place in Florida. The judge held up his hand, cleared the courtroom, and said, I'll decide the law around here. I had taught law school, so I thought everybody wanted to know what I thought. And so I'm very cognizant of which I wasn't when I started, of where the line is. The job of an expert is to assist the fact finder in understanding something that's either really complicated, like in my area, or something where there are numbers, or you're going to get a quant to come in and show science or numbers or calculations. And that is something that is appropriate for expert witness testimony. But you could also come in and say whether or not the lawyer in question in their behavior met the applicable standard of care or didn't meet the applicable standard of care. What you don't want to say is that I believe the lawyer committed malpractice. That would be a bad idea, because the judge might say, that's not for you to, that's the fact finder to decide. You're supposed to help. A good expert is a good teacher, like Bill Nye the Science Guy. Can explain something that is complicated in a way that people can understand and don't think you're talking down to them.
Do you feel that the engaging attorney dropped the ball a little bit in engaging a new expert witness and not kind of setting those boundaries and letting you know what you should be talking about, what you shouldn't be talking about, maybe how to write an expert report, things like that?
Well, in the criminal case, there was no expert report. We can talk about criminal actions, because I've been in criminal cases a half a dozen times. The criminal cases are like the Wild West, and they're not like Perry Mason. Yes, because when I got hired the first time to go out to Spokane, nobody told me what to do. What do you think of that? And so I told them what I thought, and I wrote it in a letter, and that turned out to be the expert report. We were in state court, where you don't have the more firm requirements of federal law, but and it was a national law firm that hired me, no, they didn't help me very much at all. But I got help from some of my partners in the office.
So what are the sorts of things that prospective counsel should be asking their expert witnesses during the initial phone calls? And what should the expert witness make sure to ask the attorney if the attorney hasn't already said so?
Well, let's go from the expert side, because I love experts. The first thing is you have multiple objectives in that first phone call. And because I work at a big law firm, we have almost 100 lawyers now, more than 100 professionals. I can't do much of anything until I check conflicts.
Mm-hmm.
Okay, so let's assume for this part of the discussion, we've checked conflicts and there aren't any. So the objective is to try to find out whether your experience and expertise as an expert matches up with what appears to be the important issues in the case on which expert testimony can provide assistance. So, and that's something you can't tell right away. Now, you should, if you're the expert, you should read the complaint or the most recent amended complaint, which might be more informative. Okay. And the caution I would give to a new expert, to any expert, is try to stay in your lane. Even though everybody, I can give an expert. I think I can do that. Well, maybe you can't, maybe you shouldn't. And the second thing is, and not very many litigators do this. Early on, you need to decide whether there's a positional conflict, whether you've given an opinion on facts that are like this previously, and now you're going to say, "Oh, well, that didn't count," and it has happened rarely where I've said, and very occasionally, the other side has tried to hire me after I'm already on board with somebody else. But you want to find out whether or not the opinions you're going to give are going to run into opinions you've already given on similar facts.
How do you keep track of every opinion? I mean, in a career as long as yours, how do you keep track of every opinion you've ever given on a topic to make sure that there are no conflicts?
Well, I have a really messy spreadsheet, and typically, because under the existing rules, you have to make disclosures of previous cases. They don't have to go back. I think it's only 4 years, but I kind of try to keep track of them and think, well, have I ever been asked that before? And so far, knock wood, I haven't screwed up where I've agreed to give an opinion on something that was wrong. I did have a case where, and I get a lot of calls that don't turn in to engagements. I have a separate stack for that over in the corner of my office. And I try to keep track of people who call. So in year one, I got a call from a guy I didn't know, and he asked me about a set of facts. And he said, would you be available to give an expert opinion on that, to say that the law firm in the deal screwed up? And I said, well, based on what you told me, I certainly would. I'd think about it. Okay. Year and a half goes by, a completely different lawyer calls me up and says, would you defend this Washington law firm in a malpractice case? And I said, I was engaged, and I write my report. And the very first thing that comes back from the counsel for the plaintiff that says, Mr. Leisner is conflicted out. He already knows secret information about this. And of course, my blood ran cold. I didn't have any recollection of it, but in my stack of calls that never went anyplace, and I had followed the call with an email that said, if you want to hire me, of course you haven't hired me. If you want to, got to have an engagement letter. Anyway, it turns out that a bird dog, not the plaintiff's lawyer, had contacted me. I saved my notes. My notes were delivered under seal to the judge, and I got to testify.
What an experience!
Well, I was nervous when I said, boy, I don't remember that at all. So the answer is sometimes you don't remember. And I hadn't given opinions, and this will not surprise you. The facts that were relayed to me in that initial phone call, there was nothing confidential. That all the information that was in the initial phone call was in the complaint, which of course is a public document.
Sure.
But their view of the facts was a little bit different from the view of the facts I got in rendering my report, not surprisingly. So, and it was in my sweet spot. It was an M&A transaction.
Are there other reasons that you've turned down engagements? What you said you have a stack of first calls that don't turn into engagements. What are some of the primary reasons for turning down an engagement?
Well, sometimes, and this is what happens most often, you get a call at 4:00 on a Friday afternoon from a young associate at a national law firm asking you if you can work on a case. So one of the things you ask, and we didn't get to yet, is what's the timing on this? And invariably, in 4 days, they need to make a disclosure. And after that, they have agreed to deliver an expert report. So either they didn't do a very good job of managing their time, or the first expert didn't want to give them the opinion. So if timing's not right, if you don't have enough time to review the record and do the research you need to do to give a well-reasoned and a well-supported series of opinions, you shouldn't take it. You need somewhere between 30 and 60 days to get that expert report done in a complex case. Can you get that extension? Sometimes you get the extension. Sometimes they say no. And sometimes you'll see somebody who is looking for an expert to testify on one thing for 15 minutes, and they're going to pay him a small amount of money. At least in my experience, I'm not that expert in a complex case. The better engaging counsel think that knowledgeable experts can be an important asset to the team in litigation. Because sometimes deal lawyers know right away things that a litigator won't know until after they're into the case very deeply. Litigators will get things a mile deep, but maybe not as broad as a transactions lawyer who's done a lot of deals
Sure.
in that area. So sometimes you can be a big help. So the other thing that you need to talk about early on is you need to talk about getting paid.
So when you mentioned getting paid, let's talk about that engagement letter. Are there any specific terms that you like to make sure that you have in contracts? Do you take a retainer, for instance, or do you prefer project billing?
Maybe because of my background, I'm an hourly person. I've been in some very big cases. I was involved in one of the Enron civil cases, and I got to review testimony from other experts. And my personal favorite was the expert, and this is over 20 years ago now, where they were billing over $1,000 an hour for their work, but they had a lower rate if they were traveling. And my rates are the same. And if I'm not working on the matter, I'm not going to bill for it. My experience is I'll bill on a straight hourly basis. Sometimes when you're getting started, if you don't know what you're going to give an opinion, say, let's have one bite at the apple for a fixed amount for hourly, not to exceed N dollars. And I'll tell you what I think. And you can either hire me and go ahead or not. The one thing I think that's important, among others in getting paid, is that you have to be assured that the person who's going to pay you is going to do it. If it's a national law firm that says they will pay you, you have a higher probability of getting paid.
Sure.
Most law firms want you to be engaged by the law firm to protect the work product with as much confidentiality as possible, but to be paid by the client. And I'm all square with that, but I'm going to want a hefty deposit, and I want a deposit that will cover what I'm going to do before deposition or trial. I have the unpaid bills to prove that. So occasionally things that you don't count on happen and you don't get paid.
Have you noticed a tendency for more actions to move to settlement than they used to?
The answer to that is yes, but I think that's way over 90%.
Okay.
So at least in the kind of things that I'm involved in, it would be a rare set of circumstances where I wouldn't want a hefty deposit before I started working. The answer is you should have a hefty deposit to get started. If there's a problem at getting paid at the start, what makes you think there isn't going to be a problem getting paid later on?
Let's move forward to preparations for things like depositions and cross-examinations. How do you get ready for getting peppered with a whole bunch of questions by either a judge or the opposing counsel?
If we can, let's bifurcate this.
Sure.
Depositions and trial testimony.
Absolutely.
That was one of on these 47 things I wish I knew when I'd started. One of my partners says, you can't win a case in your deposition, but you could lose it. And if experts make a mistake in thinking that when the opposing counsel is taking their deposition, that it's like at the end, there's going to be a ruling and your side is going to win. When I say it out loud, you're laughing. But the natural tendency is to think, I want to win this deposition. The deposition is an opportunity for the party calling this deposition, usually the other guys, to find out whether you have weaknesses or problems, or you have you lose your temper, or that sort of stuff. So how good are you at responding to questions? And that's a different undertaking from the trial. So let's talk about depositions. So to get ready for the deposition, if there is a space and time between when you wrote your expert report and when you're going to be deposed, you need to spend a lot of time knowing your expert report inside and outside. Okay, what if you're in a jurisdiction where there is no expert report? I think you should have an outline that looks like the front part of an expert report where the opinions are listed. Why do I think that? It focuses the mind, and it may give you a way, it would give you a document you can hand to the person taking the deposition, and it puts you in more control of what happens in the deposition than if they start peppering you with questions. The deposition may or may not be used at trial. And if it is used, it's going to be used in its totality. It's going to be used to impeach you. It's going to show that you didn't know what you were doing. And so we're doing a program in a group that I'm in July about depositions. And the title of it is Depositions Are Dangerous to Expert Witnesses. So the kinds of questions that you're going to get in deposition, you'll never get in trial. So, for example, did you read the Smith deposition? No, I didn't. You mean to tell the ladies and gentlemen of the jury that Smith's deposition was something you didn't think was important? I didn't read it. Now, that was me 20 years ago. I'd now say, is there something in that deposition that you'd like to show me? That sometimes quiets things down. Or they'll say, Smith has testified that your client is a horrible person. Would you agree with me? And those kinds of questions need to be processed. And then you need to say, could you show me Mr. Smith's testimony, please? Responding that way. For example, the idea would you agree with me, Mr. Bolmer, that today is Wednesday? So you say, yes. And would you agree with me that there are 7 days in the week? Yes, I would. And would you agree with me that your client is a scum? Oh, and if you're in that rhythm of answering those questions, you may do something that you're going to later regret. And your counsel may clean it up or may not. But you have to be wary of that. You have to process the information, listen. And when you hear things like the XYZ contract clearly provides, that the alarm bells should be going off in your head. Can you show me where in the XYZ contract it says that? We don't have time. You have to answer my question. Well, I can't really answer it unless you show me the provision you're talking about. This happened at trial once in federal court. I was being cross-examined about my expert report. And the lawyer says to me, now, Mr. Leisner, in your report, you said something that was absolutely stupid, didn't you? And I said, could you show me where that is? And the guy had gotten up to the lectern without the report. And I knew exactly where it was. I mean, I didn't say something stupid, but it's another statement. And the judge leans over from the lectern and said, is it over here on page 31? I said to myself, it's on page 32. I didn't tell him. And that just derailed the whole line of questioning because the lawyer wasn't prepared to show you. I had the same thing. I was deposed by one of the lawyers involved in the Oliver North litigation. And he said, well, the Smidlap case says this. And I said, well, do you have the Smidlap case? And the junior lawyer he brought with him didn't have it. And so you're required as an opponent to answer every question. But you don't have to answer every question in a way that makes the person asking the questions happy. And by the way, it's perfectly okay to say, I don't know. It's also perfectly okay to say, yes, today's Wednesday, and I would agree with you on these facts, that would be my answer. You can't become wedded to everything that is good for your side, bad for the other side. Because the lawyers are so good at asking modifications to the questions, you find yourself in a ditch someplace and you can't figure out how you got there.
Should your counsel be preparing you for those sorts of questions and how to answer them?
Well, obviously, I have the scar tissue for it. Good ones, good lawyers do, and good lawyers react to vituperative, aggressive counsel with calmness. You should not take the bait. This is not TV. I remember I was involved in a malpractice case on the side of the plaintiffs. We had a deposition up in New Haven. I got to walk on the Yale campus before the deposition, and it was a very small conference room at a small law firm. The lawyer taking the deposition was a big, tall guy, and he's got both hands on the desk, and he's leaning over and bellowing at me. But it's not a video deposition. And I said, well, I can hear you just fine. Why don't you sit down and stop yelling at me? He said, let the record reflect that I have been positively charming throughout this deposition. So I got to laugh. So that's quite a few years ago. I got to laugh out of that myself. Good counsel will prepare you for that kind of stuff. And experienced expert witnesses made all the mistakes. Say, I won't make that mistake again. And I've certainly had that walk home from the courtroom or from the deposition, saying, "Oh, if I get to do this again, I'm going to do a better job."
You brought up someone making a joke. What is the role of levity in these situations? When is it appropriate to break the tension a little bit with a little bit of joking around like that?
Well, I mentioned to your colleague a very excellent movie, League of Their Own, has a scene where Tom Hanks, as the manager of the ball club, is excoriating one of the players for having made a wrong throw, had thrown to the wrong base and let her run in. And she is bawling her eyes out. And this exacerbates Tom Hanks and yells, "There's no crying in baseball." Well, in one of my very first depositions, it may have been my first, they were asking me all these questions about the expert report, and I didn't know what the heck they were talking about. And finally, it dawned on me, they wanted to know if the lawyers had told me what my opinions were. They hadn't, and I was offended by the question. And I said, do I look like a short order cook in a diner? Come in and order 2 eggs over easy and home fries? At the very first break, the senior partner takes me out, and this was in Seattle, looking at the Puget Sound, and he leans over to me and he said, there are no jokes in depositions. And he was right. There can be humor in the courtroom. It shouldn't be deliberate on your part. But that was a mistake on my part. I was out of ignorance. I didn't know. It stuck with me. It was a beautiful view of the Puget Sound. He was as hot as he could be, the very senior partner. He's probably thinking to himself, what clown did we hire as our expert here? But it all worked out. So I don't think you should ever crack a joke in a deposition, even if you feel compelled to do so.
You began to dovetail into trial preparation. And how about, any contrasts, comparisons to the preparation techniques that lawyers use or should be using with their expert witnesses to prepare them for the stresses of and to be properly organized for the rigors of being cross-examined?
Well, and again, a lot of this comes down to whether or not your engaging counsel has set aside sufficient time to prepare the expert properly. My experience has been that my best performances and my best preparation for both deposition and trial, but particularly in trial, have been with lawyers who prepared me twice. So if trial is coming up in 2 weeks, a lot of this was before Zoom. Now with Zoom, it's pretty easy to do. You should be planning a couple of weeks in advance to get started, to understand the themes of what your direct testimony will be, and then to do it again with maybe some practice cross-examination. But as I said, the lawyers who've done the The best jobs of preparing me have given sufficient time. There was one of my favorite engaging counsel said to me in advance of the deposition, this was defending the defense of a national law firm post 2008 financial meltdown, said this lawyer will go crazy if you don't look them in the eye. So for 5 hours, I'm looking at the walls. I'm looking down at the desk. I never looked at this lawyer, and it really did bother them. And one of the other best ones was where they prepared me for what I could expect this lawyer to do. This lawyer, and we prepared for a couple of days before the deposition. It's another malpractice case against another national law firm. And the defense was by a national law firm. And they flew down from New York City, even though everybody was in different places except for us. And my lawyer told me that the person, she knew who's going to take the deposition, and said, after this person says good morning, almost nothing they say will be accurate. And they can be nice and they can be polite. Getting that information requires engaging counsel to be prepared to invest in you. I was in a piece of litigation that's been running for over a decade now. When I went into the deposition, I looked around, there were 15 lawyers in the room. And one of the lawyers gets up and says, "Hey, Jack, not everybody's here today." And so, because I wasn't that important, I guess. The being prepared to be in that setting, starting with making sure you got something to drink if your throat gets dry, taking the breaks you need to take, asking somebody, telling somebody, "I'm sorry, I didn't understand the question. Could you try that again?" The one thing I would say about trial, if you're preparing your direct testimony, it's again like Bill Nye the Science Guy. Whatever it is you have to say in the most complicated case you've ever been in, you have to be able to get done with it in 20 minutes at the outside, right? Like a half-hour TV show without the commercials. Otherwise, you're gonna lose the fact finders. The last time I testified in South Florida in a case like this, it was a very old courthouse. The air conditioning was hardly working. Before I started, one or two of the jurors is nodding off. You need to be able to hold their attention if you want to be successful. Preparation counts for everything. If you know the documents that you're likely to see, if you know the documents in the case, and if you understand the documents, you might know them better than the person asking you the question. I remember in that case in South Florida, they put up a big spreadsheet on the projection and started asking me about questions about it. And I saw they had the wrong date. I said, "This is from 2 years before this case." And there was a pause. That line of questioning ended. It's a good idea to really, really know the stuff. And the only way you can do that is to prepare.
One of the things you keep coming back to is having sufficient time. And that's interesting. Do you find with some consistency that attorneys attempt to engage expert witnesses in an unreasonable time frame without having sufficient time to do these sorts of preparations, go through all of the preliminary reading materials, develop their expert opinion, write the report, etc.? Do you find that these timelines are overly compressed, and should attorneys be engaging experts earlier on in the process?
You will never hear an experienced trial lawyer say, "The heck with those expert things. Yeah, they can get it all done in 15 minutes." What does happen? I've been presented with lots and lots of unreasonable time deadlines, and there's for me, there's two ways to respond to it. You can either get the time deadlines made reasonable, or you shouldn't take the engagement. I've done some stuff where somebody persuaded me to work all weekend long and knock something out. I've done it a few times. Usually when I really like the engaging counsel or I like the case. I don't think the lawyers do it deliberately. I think litigation lawyers are very, very busy. They are working against multiple deadlines, and the expert, even though I don't like to think this, the expert's not the most important deadline. And things slip and other cases get involved. And the next thing you know, that second year associate's calling you on a Friday night saying, this is Smith against Jones. I can't tell you a thing about the case. Can you serve as an expert? That sometimes happens. And sometimes you're just going to have to do the best you can. But I think all quality potential engaging counsel will agree with me. Yes, you should prepare. Yes, you should have sufficient time. Yes, you should read the record. One of the other things I think that we didn't talk about is that Rule 26 says the expert's supposed to write the report. And that means it's supposed to be your report. In my case, I make all the typos. I'm the guy at the screen on the keyboard writing the report. And so all the errors are mine. I've been edited by some really, really good editors. And I've had engaging counsel say, well, could you say this? And sometimes it's okay, and sometimes it's not.
Do you have the situation where lawyers are sometimes not necessarily trying to write the report, but giving sort of a skeletal outline of what they'd like to see, anything like that?
Sure. And sometimes it's an improvement. Sometimes it's okay. I try to be cooperative. And this is particularly the case when you're writing a rebuttal report. You don't need, I don't think, the rules require you to have the same thing in it that you had if it was a direct report.
Sure.
And I've had counsel say that my expert reports are single spaced in 12-point Times Roman type. I've had people say, "Oh, this will never do. You have to double space it." Gritting my teeth, I said, "Okay."
Absolutely. Let's move to some of the more general questions. You've been doing this for quite a long time. How has expert witnessing changed from when you got started to where you are now? And where do you see it moving in the future? Are there any trends that you're aware of or noticing in your expert witnessing career?
Well, yes. Part of it is I know a lot more about subject than I did when I started.
Sure.
So here's what I think, which is not high quality expert logic. There were a couple of Supreme Court cases now 30 or 40 years ago called Dalbert. Both of those cases stand for the proposition that the judge is supposed to be a gatekeeper and not let junk science in as an expert report. And the standards, when those cases were originally announced, a lot of lousy logic got admitted as expert reports. Clearly, if somebody has a numbers calculation that's wrong, I think the damages here are X. There's a fault in the computation. There's a fault in the assumptions. That's one thing. But my area of the law is what's called a special knowledge expert, where I don't come up with a number, but I'm supposed to explain a complex area of the law, what the standard of care is in transactions law, what corporate governance is for a director, that sort of stuff. They're more esoteric. But there has to be a logic, and there has to be a principle that is applied to arrive at your opinion. And just this last year, Rule 702, the federal rule about the admissibility of expert testimony, was amended.
Right.
To say, this is not a great translation, to say that the proponent of the expert testimony has to carry the burden of proof that persuades the judge as the gatekeeper that this meets the standard of care. This is running, the comments make this clear, that for decades, judges would say, "Oh, I got your Dalbert right here, but we'll just let expert Jones's testimony in for what it's worth." Now, in theory, it's now expert Jones's testimony has a higher bar to get over. It's got there has to be some basis on which to support its admissibility. And if you don't make that case, in theory, the judge should throw it out. And
right.
If it's not in the record on appeal, it could be tossed out. There have been a small handful of cases the change went into effect last Christmas time, end of last year. When I talked to my litigation partners about it, they were much less impressed with it than I was. It's like the French Open just concluded without Hawkeye on the lines. When the umpire says that's in, you're done. Even if the umpire's wrong.
Right.
It's because you don't have, and there's no Hawkeye yet on expert testimony to read the lines. So that's the trend, I think. But certainly, you cannot prosecute a professional malpractice case without an expert report and an expert that testifies about the standard of care.
Do you think that that's for the better? Do you think that, if what's important is a fair and just jurisprudence, are expert witnesses, all things considered, good for the process? Is it better when there are more expert witnesses?
Well, speaking on behalf of the unemployed expert witnesses, facetiously, I would say yes. I don't know the answer to that. I don't know whether we're better off or not. I have a lot of faith in the jury system. I think a lot of it depends on the quality of the lawyers and the judge in terms of how they all work together. You can get a lot of stuff that's not very good from any one of those three corners. So I don't have a good answer for your question.
Speaking of that relationship, what makes, in general, a good relationship between an engaging attorney and an expert witness?
A good one will involve shared professional respect. Part of that remember, I'm a transactions lawyer, and I have litigation partners who have helped me as an expert. I got to be a better expert because I talk to them and they tell me what to do and what not to do. So I think if there is a respect that is apparent to the person on the other side of the table, that's a start. And the next thing is that the respect will be borne out by the expert and the engaging counsel, who both do an honest day's work to do their side of the equation. But so I think it's a question of professional respect born out of proper behavior.
Before we wrap up, do you have any last advice that you'd like to give to expert witnesses or even attorneys that are working with expert witnesses?
Well, I think the most important thing is to understand the rules and to have a reasonable basis in fact and analysis and law for the opinions that you're going to put forward. And that requires you to invest time. It's like doing a deal. If you slap at doing a deal, maybe it'll work out. Probably better off if you do that last proofread in the case of an expert witness, that you do a better job of getting ready so that you don't spend the trip back from the courthouse thinking of all the things you wish you'd done. One of my partners always said, you make 3 speeches when you're going to go to trial. He said, you make the speech in front of the mirror in the bathroom in the morning, then you make the speech you really give, and then you make the speech driving home from the courthouse. And the closer those 3 can get together, the better off you are.
Thank you so much, Mr. Leisner, for joining me here today at the roundtable.
You're welcome. I was going to say, everyone calls me Richie.
All right. Well then, Richie, thank you very much for joining me here today at the roundtable, and thank you to our listeners for joining me for another discussion at the roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.